Hi, everyone. As you probably have heard, the Supreme Court has just overturned Roe v. Wade, the landmark decision legalizing abortion that was handed down in 1973. So, of course, I wanted to talk to Neal Katyal about this, what it means. And let me just get Neal on the line right now. Thank you all for joining us. This isn't a surprise given the fact that that draft leaked recently, and we're talking about what this means. Neal, hi.
Hi, how you doing?
Are you coming to me from the car?
Yeah, I'm calling from a car. That's how I'm rolling these days. So I
Okay.
have a few minutes,
Well,
but
this,
I did
thank
want to just share how devastating this day is. I mean, this was the decision today that was announced by the court is looks like pretty much identical to the decision that draft that leaked from about a month and a half ago. So it fully overrules, Katie, Roe versus Wade. So you have no right to an abortion in any of the 50 states. If a legislature decides that they want to criminalize it, if they want to say that you obtaining it means you should go to jail, or someone helping you, like an Uber driver, they can criminalize it. It is as devastating as I think many of us feared it would be.
let's talk. What I was asking you about is about the states where abortion is legal, the supposed sort of safe haven states for women who want to get a legal abortion. Obviously, there are trigger laws that will be enacted as a result of the Supreme Court decision. I believe at least 18 states. So, can you tell me what this means? Sort of give us the big picture, the impact of
Yeah,
this.
yeah. There's going to basically be two countries that can get an abortion and can about half the state.
Neal,
What that will, yep.
can you all hear Neal?
Uh, if if you're in one of those states that's criminalized, what it will mean is that you can try and go across state borders to try and obtain an abortion, but some states are trying to criminalize going across state lines in violation of the right to travel. So I suspect those laws will be few and far between, and I sure hope they aren't upheld by any sort of courts. So it's not an absolute ban on abortion in the United States. If you're in one of those states that doesn't allow it, if you have the resources, and then you can travel across state lines. Obviously, many women don't have those resources. Many, kids who are victims of incest and others don't have those resources. So it's a really horrendous decision with profound real world consequences. And when people say, oh, politics doesn't matter, the parties are the same, this or that. Right now, just today, the world looks incredibly different than it did 2 hours ago for not just women, but everyone in this country.
Neal, were you surprised that the actual decision was so similar to the draft that was leaked about a month or so ago?
I had different views on, like I went back and forth, but ultimately I came to the conclusion that the court was going to be, particularly Justice Alito, was going to be too worried about seeing as caving into any sort of public pressure. So he would leave it largely the same. And it looks pretty identical. I'll tell you, Katie, what's even worse than the Alito opinion, which is hard to top, but Justice Thomas writes a separate opinion in this case saying, hey, I don't just want to overrule Roe versus Wade. I want to overrule Griswold versus Connecticut, which is the case that established a right to privacy, a right to use contraception. He wants to overrule Obergefell, the marriage equality case, saying that also should be on the chopping block. So this is a really radicalized Supreme Court. And look, they're all smart justices, but they are completely out of step with the mainstream of American society right now.
So, what do you think? So, these state legislatures will basically be deciding state by state the specific laws that will be the law of the state, if you will. And in some of these states, abortion will be prohibited even in cases of rape, incest, or when the mother's life is in danger?
100%. And the court's decision today is express about that because the law that was at issue, the direct law, was from Mississippi. It has none of those exceptions. And yet the Supreme Court decided to uphold it. So, yes, they can have a flat ban on abortion as a result of this decision.
Is there any kind of legislative remedy to the Supreme Court's decision? Can
Yes.
this be, codified by Congress?
Yes, exactly. I'm so glad you raised that, Katie. For 3 years, I've been writing op-eds. I even recorded a song about this, about the need for Congress to act. And Congress can guarantee right now, with the stroke of its pen, Roe versus Wade rights for every person in this country. It takes a majority vote in both. I know the Republicans will say it should take a filibuster and 60 votes, and they don't have 60 votes. But my view is we already broke the filibuster requirement for the nomination of these three Republican nominees to the Supreme Court. They only got through with 51 plus votes. And given that their most important decision is overturning Roe versus Wade, it sure seems to me it's an easy case to overrule to not have the filibuster apply to the much more modest step of this legislation to codify Roe. I mean, if you can do it for the big thing of a Supreme Court nomination, how can you not break the filibuster for a smaller but very, very important thing, guaranteeing the right to a safe and legal abortion in this country?
But given the complement of the Senate, given the fact that, it would be very hard to get 60 votes, I mean, this sounds very much easier said than done, Neal.
Oh, I know. I don't think it's going to be easy. I think it's going to be hard. And by the way, I'm saying it should be 51 votes, not 60.
No, I know
and
that. But in case
and
they
I'm
don't
sick
get
of
rid
our
of the
party.
filibuster.
Katie, I'm sick of our party not trying. It's putting in the too hard box. I mean, we have a Democratic majority in the Senate when you consider the vice president's vote, and we should use it. This is what it's for. This is like, I guarantee you, if the shoe were on the other foot and the Republicans were in this position, of course they would be doing everything in their power, just as they did to block the confirmation of, Merrick Garland to the Supreme Court and install their own people. And, this is fully within the rules, unlike what Mitch McConnell did there. So, I think we have to try and not give up right away, because there is no other solution. These justices are on the Supreme Court for their life. Well, they're not going away. So we have to have some other strategy. And I do think your question is right. That has to involve legislation.
Let me ask you about Clarence Thomas. There's increasing evidence that Jenny Thomas, his wife, was part of this whole plan to overturn the election in a pretty intimate and damning way. Does this affect Clarence Thomas's standing on the Supreme Court? And is there any kind of steps that can be taken given the fact that his wife is so involved in this political and I mean completely false claim of a rigged election and maneuvering in a very specific way behind the scenes?
Yeah, so I don't want to get into that stuff about the Justice Thomas's life and those situations, but I think, today we should be focused on what Justice Thomas actually wrote in his judicial opinion, which is as radical a judicial opinion as I've ever seen, because it calls for the overruling of foundational precedents. I don't think on his chopping block list, interestingly, was Loving versus Virginia, which was the Supreme Court case that guaranteed the right to an interracial marriage, something which, obviously he has a particular stake in. But, it is a really scary day to think that the U.S. Supreme Court is now going to be thinking about overruling really the most canonical decisions that, shape our lives. I mean, I don't know if Brown versus Board of Education is next on this list of things to overrule. It is, I cannot overstate how radical Justice Thomas's opinion is.
Well, I have not read it yet. I'm going to be reading it as soon as we sign off. But do you have another couple of minutes, Neal? You can talk to me.
I got about 2. Yeah.
Okay. You know, I was reading about Justice Ruth Bader Ginsburg and her discomfort about the basis and the foundation of Roe v. Wade, saying it was when it was decided under the right to privacy, it should have been under the equal. As a constitutional scholar, was Roe at its inception flawed?
Well, I think that Justice Ginsburg was right to say it should have been put on the stronger footing of equal protection. That's not to say that there isn't a right to privacy right. There obviously is. I think almost all mainstream constitutional scholars accept that, obviously except Justice Thomas, but most do. But I think the most important point here, Katie, is that what were all the criticisms of Roe versus Wade, and they've been hashed out for many years. It was a trio of Republican appointed justices in 1992 that said, look, we get all that. It should be more about equality, less about privacy. But Justices O'Connor, Souter, and Kennedy said Roe versus Wade is the canonical precedent. It's a super precedent. Social expectations have crystallized around this right, and we, the Supreme Court, can't overrule it without doing profound damage to our legitimacy and our standing with the public. That was Republican justices back then. Roe versus Wade itself was a 7-2 decision with 7 of the 9 justices appointed by Republican presidents. So you've got that for 50 years, and then you got this today, as radical a switch as you can come up with.
And precedent meant nothing to the justices who decided to overturn Roe.
Nothing. And again, if you can overrule Roe, you can overrule anything, because Roe is the hardest decision to overturn because it is this super precedent. It's something that all Americans or most Americans know this decision by name, unlike almost anything else. And it really did have profound changes to our social fabric. And it's been kind of baked into our lives now. And to flip that, if you can flip that, I just think it's going to be interesting to go to the Supreme Court next year when I start arguing again in October. And, precedent is, Katie, the essence of what we do. We're always basically asked about, how does this position of your client square with our precedent? And, that whole line of thinking just feels so antiquated in the result of today's decision. It's a real shock to what the rule of law has been about.
And for people who are very upset watching this, Neal, what would you say to them in terms of anything they can do?
Well, I do think people's voices need to be heard in a peaceful, respectful way. And so I think that's really important to demonstrate. But I think it's really important to call for legislation and call for legislation that breaks the filibuster requirement. So it's a simple majority in the House and Senate. It's easy to get that in the House. It shouldn't be that difficult to get that in the Senate. But that is the legislative path. There's no other path. You're not going to remove these justices from the Supreme Court. That requires a 2/3 vote and of the Senate.
And the court, as someone just chimed in about.
Yes, but that will also require legislation and a supermajority, unless you try to exempt that from the filibuster. So, the more modest step is a Roe versus Wade fix that guarantees those rights. That's a lot easier to achieve than something as dramatic as packing the courts.
And I know you have to go, but yesterday's decision that basically said states can determine if people can carry guns publicly. Can you just give us some perspective on that?
Yeah, I mean, it's flatly inconsistent with what we just heard today from the Supreme Court about abortion. So yesterday's decision says that in a state like New York that has a law that makes it hard to concealed carry firearms, they said that violates the Second Amendment, and they've taken that decision away from states. So states can't have that. They say, no, there's a guaranteed right to concealed carrying of firearms. Today, they say there's no right to an abortion. We're going to return it to the states for them to decide. And, it is true that there is the right to bear arms in the Second Amendment, but there's no right to concealed carry in the Second Amendment. That's obviously a judicial stretch and a judicial interpretation. By contrast, the right to an abortion has been firmly recognized for 50 years by, as I've been saying, a whole bunch of Republican nominated justices until today. So, it's not clear to me that the right to a concealed carry stands on any sort of stronger constitutional footing.
And people seem to forget the second part of the Second Amendment, which is a well-regulated
Of course.
militia.
Absolutely. Absolutely.
Well, Neal, thank you for hopping on the phone. We
Thank
appreciate
you.
it. Maybe you'll
Thank
give
you.
us, maybe we can have another conversation soon as the dust settles a bit on this and
Yeah.
people learn more about it. Thank you, Neal, and thanks
Thank
everyone
you.
for watching.
Thank you. And thanks for watching. Bye-bye.
Talk to you. Bye.